First case this morning is Elizabeth Palmer and William Burr, filed 04-10765-DS, set for a show cause. We have parties present for that.
I'm neither party for that.
All right. Ms. Kraus, is this your matter?
This is.
Can you update me on this, please?
Yes, Mr. Burr has two cases this morning, specifically in regards to the case with Elizabeth. This hearing was adjourned from July 10th to monitor the defendant's ordered on arrears monthly payment of $165. There was a $300 payment that was received the day prior to the last hearing that has dispersed. It's an arrears only case in the with a balance of $16,962.44. Both of the hearings did address if payments were made, they would be adjourned in advance. But because that payment was made in one payment, I wasn't sure of how the court felt about that, but he did make a payment specifically for each of these cases in the amount of $300. I am aware that he's not here, but given that payment, I wouldn't be opposed to monitoring the month of August or September and then adjourn it again if payments are made.
So tell me the timing again of the payment. It was made when?
On July 9th, the day before that hearing. And I don't recall if we discussed making additional one or just monitoring things. That's the reason I didn't adjourn this hearing.
I assume, when was the previous payment before that?
Previous payment before that was back in April. You did have a discussion about making consistent payments, and the court would continue to monitor him for approximately 6 months before we would remove the show cause.
Yeah, in my mind, the $300 payment was for the month ending on the last court date, not going forward.
And
So he
that's
hasn't made
kind of, yeah,
he hasn't made a payment since then. So let's
correct.
do, and for his failure to appear today, then let's just do bench warrant, this 25% bond on his arrearage.
Okay.
Let me call his other case and we'll do that one as well. This is Sherry Ferguson and William Burr, file 09-13046-DP, set for a show cause. Mr. Burr has failed to appear again today. Ms. Kraus, as to this file?
This is additionally an arrears only case with an obligation of $88 a month. The same, a $300 specific payment was made to this case the day prior to the hearing. The balance on this case is $5,967.04.
For his failure to appear and make payments, let's do that 25% bond condition based on his arrears. And we'll see what he says when he shows up next time. Christy Wheeler and Cody Frost, file 16-16273-DP.
Neither party.
Looks like we do not have Mr. Frost with us. Ms. Kraus, can you update me on this one?
This hearing was adjourned from May 22nd to monitor the defendant's continued monthly payments in the amount of $301 and additional good faith payments towards his overdue child support in June, July, and August. The defendant did make a payment on Monday, of which a $310 payment on Monday, of which $309.29 dispersed to this specific case, and 71 cents went to an additional case that he has that's arrears only. I haven't had any contact with him. I actually seen that payment this morning as I had prepared for court yesterday and did not see that payment disperse. The balance on this account is $16,675.31.
So since the last hearing, which was in what, February or March?
In May.
Or excuse me, May. So here we are in August. He's only made it, is it only 309, or excuse me, 310 that he's paid?
He paid nothing in June, July, and then just made that payment on Monday that dispersed. Prior to the May payment, he had not made a payment since February, which was, it appears to be $302.
And he's supposed to be paying $301 a month, right?
Yes, and reasonable efforts or good faith efforts, as there's no ordered on arrears amount for this case.
Yeah, he has not done that. For his failure to appear today, let's do a bench warrant bond in the amount of 25% of his obligation, his arrears obligation. And he can explain himself to me once he appears. All right, Jessica Schultz and Timothy Bennett, file 24-19620-DS. I do see Ms. Schultz is with us. We have Mr. Bennett.
We do not.
All right, Ms. Kraus, can you update me, please?
Yes, this hearing has been adjourned 3 times, most recently from July 10th to monitor good faith payments of support, and was referred to friend of the court for a new support recommendation. The defendant did have contact with the office on August 6th to get the hearing date information for today and was provided that information. He was aware that he did have some conditions that he would need to submit to our office. I've not received anything and have no good address for him on file as well. So he was aware of today's hearing. His obligation is $703 with an arrears balance of $20,342.50. There's been no payment made since the order entered in 2024.
Ms. Schultz, have you had any contact with Mr. Bennett about his child support?
Not with Mr. Bennett directly, no.
Well, with anybody on his behalf?
Not about child support. I know he's not in rehab and it's the same story. He did apply, but I don't think he got approved, and he bought himself time. And he did, you stated a couple months ago that if anybody paid any of his bills on his behalf, 3 days before court last time, which I didn't check his stuff, somebody paid all of his fines off in Jackson County right before our last court date, and I didn't check it. So I don't know where he is, but I know he's in Jackson, Flint, downstate somewhere, bouncing around, and here we are.
All right. Well, for his failure to appear, then I'm going to issue a bench warrant. We'll do the standard 25% of his bond or of his arrearages for bond, and if he wants to get out, he can pay that, and that then will go towards child support. Is there anything else that you want me to be aware of, ma'am?
No, I just appreciate your time. It's a long drawn out issue. Thank you.
It is. Yep. Take care. Have a good day. Ms.
You too.
Kraus, is there anything else that we need to do today?
No, just in regards to that he failed to comply because you gave him specific instructions. As he indicated, he was reapplied into a program that he would receive funds to go towards his support. We did not receive any of that information.
All right. Was this the one that was an issue of abatement or not?
Yes, we are regardless, we are initiating a new support review, which should continue in regards to that. He was supposed to submit.
Do a medical needs verification.
Yep,
and
we do have some of that information from the prior hearing, but he was to indicate where he was participating, any funds available for any of that type information, and to get information regarding his Social Security disability attorney, because he had indicated he had applied for that as well, but no documentation.
All right. In the documentation you're going to prepare for today's proceedings, would you please make a note that he has failed to supply the documentation he was previously required to submit, and he's failed to appear, so a bench warrant will issue with 25% of his current arrearage amount. Thank you.
Yes.
Thank you.
Have a good day, Ms. Schultz.
You too.
Ms. Kraus, I'm going to recall the Bennett matter. It appears that he has just appeared today.
Which case? I apologize.
Yep, this is Jessica Schultz and Timothy Bennett. It's file 24-19620-DS. Mr. Bennett, are you with us?
Yeah.
We called your case about 15 minutes ago. Where were you?
I don't know, I just got in line.
I know that, but your case was scheduled for 9 o'clock. It's now 20 minutes after. Where were you?
I don't know, I just found your number. I got in line. Sorry about that.
Well, Ms. Schultz was already here and she's now gone. Ms. Kraus, can you update me again as to this one? Remind me where we're at?
Yes, this hearing had been adjourned 3 times, most recently from July 10th to monitor good faith payments of support, and was referred to our office for a new support recommendation. Additionally, the defendant was to provide documentation on a letterhead in regards to a participation in a program and when funds would be available for the child support obligation. And he was also ordered to provide contact information for their Social Security disability attorney to the friend of the court within 7 days. Friend of the court has recently received return mail, so we have no good address for the defendant and have had no contact outside of him calling the office last week to get information regarding today's hearing.
Okay, I got
Mr.
my new address, and I got my disabilities number. If you want to call them, I just spoke to them yesterday about disability. I'm getting in a month or two. I'm getting disability. I'll be able to pay off the child support then.
Mr. Bennett, you were supposed to provide information to the friend of the court and you failed to do that. Why is that?
I got the number for the disability lawyer right now, if you want it.
You were supposed to have it before today. Yes, we'll take it from you, but you were supposed to have it before today. You were also to provide information about the payment program or the payment possibility through the program that you're in. Where is that information?
I don't know about that program. They've been trying to get hold of them. They won't get a hold of me. I don't know. I guess they're not gonna do it. But my disability is gonna go through. I spoke to them yesterday. It's gonna go through. It's just gonna be a month or two.
What documentation do you have of that?
I got a phone number you can call. My lawyer.
Ms. Kraus, am I remembering correctly that the last time we had a hearing, there was a gentleman that was assisting Mr. Bennett from the program?
Not at the July hearing. It was the prior hearing. I believe it was on May 8th, but he had left that program, and the gentleman that I had spoke to had indicated that he did not want the funds to go to support. It was going to do something to help with an attorney, or I don't know if it was for this case or his criminal matters that he was being charged with in another county.
So Mr. Bennett, sounds like you chose to use the money to go someplace else with it. Why is that?
No, I didn't. They didn't do nothing with it. They didn't do nothing with it because I got a program. They won't help me.
Sounds like they did help you. They gave you money and you used it for an attorney rather than send it to your child support.
No, I did not. I don't know. No, I didn't. they can't money at all.
So how long you been at this program now?
I'm not in this program anymore.
So where are you at now?
I'm at I'm in town right now. I'm at where I live now.
Which
Friends.
is where? Which is
In
where?
Jackson. In
You got an
Jackson.
address? Have you
Yeah,
got
I
an
do.
address there? Tell me
Yes,
it.
I do. It's
What is it?
1935 Springport Road, Jackson, Michigan, 49202.
Are you working?
No, I'm not. I'm waiting for disability.
Who told you that you couldn't work? Mr. Bennett, who told you that you couldn't work?
Disability.
Who told you that you couldn't work?
Disability. I can't work because I'm getting disability.
I understand that you want to get disability, but that doesn't mean that somebody told you that you can't work. So I'm asking you, who told you that you can't work?
Disability told me I can't work because I'm getting disability.
You haven't got it yet. Is there a doctor that told you that you can't work?
Yes.
Where's that documentation?
My doctor at the program told me I can't work.
Then why haven't you submitted it to the friend of the court?
I don't got it anymore. I can call the program and see if they can speak to you.
No, this is you. You are the one who is responsible for making your payments. We're not chasing your records. You are responsible for getting that information. And if you don't do it, I'm going to throw your butt in jail. Do you understand me?
Well, it's not gonna do you no good to put me in jail.
You've been doing nothing. You haven't given me anything.
I'm gonna have
We've
disability.
been doing this for 3 months.
I'm gonna have disability here in a couple months.
That's what you say, but you haven't done a single thing that you've said before.
You want to phone to the lawyer that I got?
I don't want to talk to anybody except for you. And I want you to get the information that we've been asking for the last 3 months.
Okay, I will.
You've been stringing me along doing absolutely nothing.
I'm waiting on disability. I don't know what to do.
I don't care what you're waiting on. I'm not just going to play this game where you keep stringing me along saying somebody somewhere might give me a disability. I got nothing from you that says that you can't work. I got you bouncing out of programs as soon as you want to. I got you not accepting dollars for the child support and then saying that they didn't give it to you, where the guy 2 months before said we'd be happy to give it to you. All you got to do is apply for it. Everything that you've ever told me has been a lie, sir.
I applied for it and they didn't give it to me.
Everything that you have told me has not come true.
I'm here. I don't know. I'm here.
You're here
keep
20
going.
minutes late is what you're here. You haven't done a single thing, and you're late, and you've got excuses that don't make any sense.
I was trying to get paperwork, okay? I haven't seen my kid in almost 2 years.
You haven't seen what?
My kid.
When was the last time you paid for your kids?
I'm waiting on disability and I'm gonna pay off the child support. I'm paid off. when I get disability.
If you want to see your kids, file a motion. That's what everybody else has to do. It's got nothing to do with child support. Those two things do not necessarily go together. You pay because your kids have bills, not because you see them or not. If you want to see them and you haven't, file a motion. Nobody is stopping you from doing that.
I'll get a lawyer. I'm gonna get a lawyer.
Feel free.
I will.
Ms. Kraus, what do we have for a monthly payment on him? Anything?
His obligation is $703 with an arrears balance of $20,342.50. There's been no payment since the order entered.
In the month of September, Ms. Kraus, when's our next, when would be the first date that we would normally have hearings on? Do you have that?
September 11th.
All right, that gives him 4 weeks.
You want the phone number to my lawyer?
No, I do not want a phone number for your lawyer. I don't think you understand what we're doing. I am not your caseworker. I am
Yes, I
not
do.
going to make phone calls for you.
I'm getting child security. I'm getting child. I'm getting off. I'm gonna pay it off.
Here's what we're going to do, Mr. Bennett. You're going to make a payment of $703 before September the 11th. If you do not make the payment by September the 11th, you will go to jail for 7 days. In addition to that, you will get a letter from your Social Security lawyer as to what the status of your Social Security case is. If that letter is not here by September the 11th, you would go to jail for 7 days. Do you understand what you need to do?
Yeah, I do.
Write it down.
I'm not gonna be no, that's my social security. I don't know.
Payment of 703, letter from your lawyer as to the status of your Social Security disability claim. Do you have any questions about that, Mr. Bennett?
No, that'd be it. Thank you.
No excuses, because you're going to jail if you miss either one of those. Do you understand that?
I got it.
You're breaking up. All I want is a yes or a no.
Yeah, I'm not gonna have
All right.
I'm not gonna have money, but
Your Honor,
Yes.
was the court able to hear what his address was, as our office does not have a good address and has received return mail?
Yep. 1935, 1935, Springport Road, Jackson, Michigan, 4920. I believe it's 2, but you might want to check on the zip code.
Okay. And would that be in the order that our office is to update that address by your order?
Yes. Yes, please. That's all for today, Mr. Bennett. Make sure you get your stuff done.
yeah, I'm not gonna have money. Yeah.
You're free to go, sir. Jill Bogus and James Bogus, file 17-17094-DM for show cause. We have either party present for that.
Neither party.
All right, Mr. Bogus has failed to appear. Ms. Kraus, can you update me on this one, please?
This case, give me just a moment to grab the form because we went out of order. I apologize.
No, my fault.
Okay, so this case is a specific case that the defendant is to pay $163.50 monthly. The sum is composed of $109 for current support and $54.50 towards overdue support. The arrears balance on this case is $11,676.07. The last hearing was adjourned as the defendant had indicated he had some other criminal matters that needed to be handled. During that, there was an ex parte to the court to make aware that he was in treatment. We have had contact with him, but no additional information. I have tried to reach out to his probation officer assigned in Flint. The only information that is available on Vine is that he is under their supervision until April of 2028. I have left several voicemails for Mr. Bogus that does identify his first and last name, but I do not have any information to indicate that he is still in treatment as he was supposed to be out July 22nd.
All right, and I think the last time the order or the support enforcement order says that if you're not able to confirm a valid reason for his non-appearance, a bench warrant would be ordered.
Yeah, at that time you had indicated the check mark because we were able to confirm it, and I spoke with him and he had indicated he should be out July 22nd, so we adjourned it to today. But I've had no contact with him since to confirm any other information.
All right, it sounds like we've done everything that we can to get his attention and make sure he knows he's supposed to be here. So for his failure to appear today, we'll do a bench warrant with bond and the 25% of his arrears. All right, the next matter is Abriana Montross versus Adam Fletcher, file 24-19681-UN, set for a show cause. We have Mr. Fletcher with us.
We do not, neither party.
All right, Ms. Kraus, can you update me on this matter, please?
Yes, I do believe he had a court-appointed attorney, Mr. Larry Brown.
That's correct.
Good morning, Mr. Brown. Have you had any contact with Adam Fletcher?
I had contact just yesterday. It was very sporadic and broken up. The connection was extraordinarily bad. So I really didn't get a lot accomplished in speaking with him.
All right. Did you initiate that call or did he initiate the call to you?
I called.
All right, thank you. Ms. Kraus, where are we at in this matter?
This hearing was adjourned from July 10th. The order of the court was for the defendant to make a full monthly payment of $360 prior to today's hearing, or the defendant would be committed to 7 days in the Otsego County Jail if the full payment was not made. I have not had any contact or payments made since the last hearing.
All right, let's issue a contempt finding for his failure to pay and do a bench warrant for his failure to appear. The contempt will be 7 days in jail, as that was what I told him he would do if he failed to make his payment last time. And the bond on the failure to appear will be 25% of his arrearage. This looks like it'll be a hefty sum because he's owed, what, $40,000?
Correct.
Any questions about that?
No, Your Honor.
So you're
All right, thank you very
indicating
much.
he's to serve 7 days? Or,
Yes,
okay. And then what would the bond be?
bond
for?
was 25%. The bond was for his failure to appear. The contempt was for his failure to pay.
Sorry,
And
I
then the bond
appreciate
is for-
that.
Bond is for his failure to appear. The bond amount will be 25% of his arrearage. The 7 days in jail would be for his failure to pay as he was ordered to pay last time. Thank you very much for your time, Mr. Brown. Appreciate it.
Your
Thank you,
Honor, Mr.
Judge.
Ben-
All right, this is the matter of April Wiggs and Johnny Wiggs, file 98-7823-DM. Mr. Wiggs is present. Ms. Spillane, is this your matter?
Yes, sir, it is.
Can you update me on this one, please?
Absolutely. This matter was adjourned from, or I'm sorry, he was arraigned on February 27th and then adjourned to a status conference to kind of check the status on his incarceration and his plan for once he is released. I did look into it and it appears he should be released on Tuesday. This is an arrears only case. He has an arrears only obligation of $382 and his current balance is $96,183.74 with last payment received back in 2021.
Mr. Wiggs, you're in a big hole.
Yes, I am, Your Honor.
So what's your plan upon being released on Tuesday for starting to dig out of that hole?
Down the hole, Your Honor, is I am currently a trustee here in Emmett County Jail. Usually 4 people are trustees. There's 2 as of, there's nobody else in that position. God, I did such a great job here, Your Honor. I've been offered a maintenance position by the courthouse. And I've got a few COs I can give you. Ms. Blaine, you can write these down, you can for me. And I can also, I can have maintenance, sergeants, Samuel, jail administrator. They said, all use me for reference. I've done great things here, so. Kurt, I feel great. I'm ready to tackle this.
So when you get out, do you have a job pending or are you just gonna have to look for work?
I work at Fast Eddie's, which is on US 31 here between the golf course and McDonald's in Petoskey, but I am to apply to Emmett County.org. I have a link here that they've given me to apply and they'll flag that application. And when the application comes due, Dave Clark, which is head of here in Emmett County, will pull that app for me, give me an interview, and they actually the position fine. I just can't apply anymore. You can check that through Sergeant Ben Warner, Sandy Hunt, jail administrator, Sergeant Wilbur, Cindy Snyder. I've got all kinds of references, but I've done some great things here.
All right, well, I'm pleased to hear that you've used your time wisely.
Absolutely.
But when you get out, you still have this obligation, which means that you need some work and you need to be able to start making some payments. So I'm going to adjourn this matter for about 30 days. What mailing address do you want us to use once you're out of the jail system?
I can get to be 599 Gather Ridge Drive.
We're picking up a lot of background noise. Is that from RGC? Is
Not
it?
sure if it's RGC. Not sure which jail it's coming from.
Well, let's mute RGC and just find out. Could you give me that address again, Mr. Wiggs?
Yes, Your Honor. It's 539 Valley Ridge Drive, Petoskey, Michigan.
Slow down on the name of that. What's the drive? What's the name of the drive?
I'm sorry, Your Honor. Valley Ridge Drive.
Valley, V-A-L-L-E-Y.
Yes, sir.
Valley Ridge.
Yes, sir.
All right. And where's that at?
Petoskey, Michigan.
What's the zip there?
49770.
All right. So we'll send the notice of the next court hearing to that address so that you know when it's going to be. In the
Absolutely.
meantime, I need you to keep track of all of the employment applications that you make while you're out. If you get a job, great. If you don't get a job, you need to be able to show me that you've been working hard to try to get a job. So don't just wait for 1 or 2 to call you back. You got to keep applying. You should be out there every day trying to get 2, 3, 4, 5 every day. And keep track of those so that you can send them in. If you don't have a job by the next court hearing, I need you to send in a list of where you applied to the friend of the court 2 days in advance of the court hearing. Okay, so
Yes. Yes, Your
30
Honor.
days from now, approximately, there'll be a court date. About 25 or 26 days from now, you're going to need to mail it so that it gets here 2 days beforehand, so that we have a chance to process it and look at it and understand it. If you get a job, then you're required to give that information to the friend of the court once you get it. So call in and say, hey, this is where I'm working. This is what my boss's name is. This is the address. This is the phone number, all that kind of stuff. Do you have any
Absolutely.
questions for me, sir?
No, Your Honor, other than, yeah, as I said, I'm ready to tackle this, so. Great things
All right.
happening here for me, and I'm thankful.
Good. I'm glad to hear that things are going better for you. Ms. Spillane, is there anything else that we need to do today?
No, sir.
And
Thank
you got that full address for him now?
I do.
All
Can I
right.
give you a
That's
number? Can I give you a number before we leave? I'll give you a phone number. It's gonna be the same number. It's
Yep.
gonna be 231.
Go right ahead, sir.
Thank you. 231-340-8192.
You have that, Ms. Spillane?
Yes, sir.
I'll be
All
calling.
right. Thank you very much, sir.
Thank you.
Have a good day.
Thank you.
It's a matter of Sabrina Ball and Alan Severns. That is file 19-17728-DP. We'll wait while Mr. Severns gets somebody to assist him with the audio on his hearing.
Can you guys hear me? Am I still muted?
No, we're good now. Thank you very much, Mr. Severns.
All right, good.
All right. We've called your case now. I'm going to hear from the friend of the court, and then I'll come back to you in just a minute, sir. Ms. Blaine, can you update me, please?
Yes, sir. We had received a writ of habeas corpus for Mr. Severns. As you can see, he is incarcerated right now. I don't know if he has an anticipated release date or not yet. He does have a support obligation of $417 and a current balance of $12,075.24. Last payment received was back in February of 25 in the amount of $500.
All right. Mr. Severns, how long have you been incarcerated and how long before you get out?
I have been incarcerated since April of 2026. And my earliest release date is 11/4/27.
All right. Michigan law has what's called an abatement process, meaning that your child
Yes, sir.
support can be held, put down to zero temporarily while you're incarcerated for more than 6 months. So it sounds like
Yes,
from
sir.
April of 26 through November of 27 is about a year and a half. So that qualifies for that time period. We're going to reset this matter for December of 27. Just so that we have a way to contact you and restart this case, or at least talk about what happens next.
Yes, sir.
And you're going to need to, once you are released from prison, you're going to need to contact the friend of the court's office and talk to them about where you're living, what your employment likelihood is. We'll give you some time, a little bit of time to get started there, but it's going to start pretty quickly after you get out. This is not going to go away. But while you are
Yes, sir.
incarcerated, it is appropriate to not let this build up unnecessarily. So we'll go back to the April date and start that abatement and then take off anything that's abated between then and now, and so that your time period is consistent. Is there any other information that you want me to have at this point, sir?
Yes, sir, Your Honor. My taxes for the year of 2024, they were taken and none of it was applied towards my child support. I don't know where they went, but if you contact the Bureau of the Fiscal Service, it says that all of my tax offsets were all applied to child support. It should have been about $5,200 or something like that should have been applied to it, and it doesn't show that there's been any type of payment to that. So I don't know if you guys have a way of contacting them to see what's going on with that payment or whatnot. But 5,000 of that should have been taken off in 2024, or at the beginning of 2024, Your Honor.
Ms. Spillane, is there a process whereby the friend of the court has access to that information?
That's a tricky one. I would have to look into that more. Certainly, this would be a conversation that maybe Mr. Severance should have with us upon his release so that if we need additional information from him, we can get it.
All right. I'm going to direct Ms. Spillane to do whatever digging that she is able to do into that, Mr. Severance. And if she's able to come
Yes,
up
sir.
with any information, I'm going to have her give you a letter. There are federal rules that the states have to follow about what information is available and what information is not. So I don't know if she's going to have access to it or not, but because you brought it up, I will ask her to at least inquire into the areas that she has access to and to send
Yes,
you a
sir.
letter indicating what she found so that if you need to do additional digging once you are out of the prison system, or if you think that you can do it while you're in the prison system, you're able to do that. So I'll ask Ms. Spillane to do that within the next 30 days or so and send you a letter indicating what she found. And if there's some information that she can give you as to where you can dig it up, if you wish to do further, I'll ask her to include that in the letter as well. Is there anything else
Okay.
that you want me to be aware of, sir?
No, that's all, Your Honor.
All right, Ms. Spillane, is there anything else that we need to do today?
No, sir.
All right, thank you very much, Mr. Severance. Yeah, have a good day.
Thank you, you too.
All right, the next matter is Melissa Klein and Dustin Price. That's file 11-14071-DS. I do see Mr. Price is with us. Ms. Blaine, can you update me on this matter, please?
Yes, sir. This matter was adjourned from July 10th, and the defendant was instructed to make a payment before today's hearing. We started a new support review, and parties were advised that they could discuss any of the amount that was owed to each other and that they had the option to waive that money for if they had an agreement on that. We also received information from Ms. Klein that verified that one of the children was in fact staying with Mr. Price, and that child support for that individual child has been abated. Mr. Price has a support obligation of $889.37, which also includes reimbursement for medical expenses. His current balance on the account is $10,998.85, and we did receive $50 last month.
All right, Mr. Price, what information do you want me to have?
I am still currently working on filing a motion. It is a little delayed because after speaking with my children, they wanted to have an opportunity to try to talk to their mother first to see if there's an easier way to resolve this without going back to court. And she had shut them down every time. So I will be moving forward with filing a motion. But I also will be able to make another payment here next week. I don't know what that amount will be just yet. But I will make another payment next week on payday.
Are we talking $50 or are we talking closer to the $889 that you actually owe each month?
As close as I can get to that number. I still have my mortgage that I have to pay and several other bills. So along with miscellaneous expenses for our oldest daughter who is moving into Michigan State on August 25th. She still has other furniture and things that she needs.
I don't doubt anything that you're telling me, Mr. Price, but those are all things that everybody in the world has bills for.
Yep.
Lots of people have kids moving to college. Lots of people have mortgage payments. Lots of people have bills for medical. All of that stuff is entirely normal.
Yep.
The French court calculation takes all of that into account in dealing with what the child support amount is. So you owe $889 a month and you owe almost $11,000 in arrearages. If you're not going to be making that on a regular basis, I'm going to have to start thinking about jail. We had this conversation already once, and I gave you an opportunity to make some agreements. Apparently you weren't able to do that, and I'm not faulting you for do that because I understand it takes two people to agree. But at some point, payments need to be made. And I get it that you disagree with them, but it's still an obligation, and I have a duty to enforce that obligation. So $50 a month doesn't cut it.
Understood.
So unless you want to keep seeing me month after month and having me decide whether you go to jail every month, payments need to be made. So when's the next payment going to be made?
That is going to be next Friday on my payday.
And why is it that you don't know how much the payment is going to be out of that check?
Well, like I said, I'm in our last hearing, I make $16 an hour and I still have a multitude of bills that I have to pay. So I would rather not have my house be foreclosed on or my utilities shut off. So once I get that paycheck, I will be able to determine how much I can pay moving forward.
I think we had this part of the conversation last time as well, Mr. Price, but I want to make sure that you understand what you're flirting with. The question in my mind is, do I need to send you to jail? You're asking about whether or not you owe some money to somebody. Are those two things the same in your mind?
Whether I owe money to somebody or whether I go to jail?
Yes.
I mean, I'm not sure I understand the question.
Let me back up and try to rephrase it then. If you don't pay your bills at some point in the future, the home or the bank can come and try to repossess your house. That takes a number of months to do it. If you don't pay this bill, you will go to jail for 7 days every month that you don't pay this bill. I would think that you would want to stay out of jail a little bit more than you would want to make your other payments. That's just me. I'm wondering if you have that same mindset.
No, I do have that same mindset, but also maintaining the home that my children still currently reside in and my youngest child resides in 50% of the time during the summer, and they had lived in for the last 5 years is also equally important. I'm trying to juggle both at the same time, and I apologize that it doesn't seem that way.
Oh, I get what you're juggling. I totally understand that, but I just thought you might want to know that my view is that this bill is more important. And because you have not made a significant payment after I spent quite a bit of time last month talking with you and not throwing you in jail then, I would have thought that you would have done better than $50.
If I had more,
go right ahead, sir.
I was going to say, if I had more than $50 to apply towards it, I would have.
My comment, sir, was going to be that quite frankly, $50 is a slap in the face.
Okay, I'm sorry you feel that way, but I've also gotten shut off notices for my power, other things like I did what I could, and apparently that wasn't good enough. So I don't know where we go from here.
Well, where we're going to go from here is 30 days from now, you're going to pay $889, or you are going to go to jail for 7 days. So that will be
Okay.
2 months that I've given, 2 months then that I've given you to pay your bill. So you make the decisions as to which balls need to stay in the air. You make the decisions as to which bill is more important to you. But I'm telling you, this is what's coming. If you've not made the full payment in 30 days by the next court hearing that we have, you will go to jail for 7 days. And we're going to do that every month until you figure out how to make your bill payments. Are we clear?
Absolutely.
All right. I'll see you in 30 days. Next matter is Ashley Bagby and David Losiewski, file 14-15600-DP. Ms. Bagby with us?
Yes, I am, Your Honor.
All right, good morning.
Good morning.
Ms. Blaine, can you update me on this matter, please?
Yes, sir. This matter was adjourned from June 26th to monitor Ms. Bagby's payments. You had indicated that hearings would be adjourned 2 more times, and if she continued to meet the obligation, we would eventually be able to stop the hearings. Her support obligation is $388 plus an additional $194 ordered on arrears. Her current balance is $20,047.62. For August, we've already received $460.83. For July, we received $1,091.13. So money is coming on a fairly regular basis.
Ms. Bagby, it sounds like you're doing what you're supposed to be doing, which is good. Congratulations on that. Do
Thank
things
you, Your
look good moving forward?
Yes, Your Honor.
All right. On an unrelated, well, not unrelated, but on another note, are you and Mr. Losiewski able to at least talk to each other in a business-like fashion now?
Unfortunately not, Your Honor. He still has me blocked. I do try calling him once a week to speak with my daughter. I do leave voicemails, but he doesn't contact me back.
Well, I'm sad to hear that. Are you, his claim, and again, I'm not making any findings, but his claim is that you have said some things that were unkind about him. Are you controlling that behavior?
I am, Your Honor.
All right. Sounds like things are going pretty well for you. I hope that you are able to have contact with your kids, but the child support side of things is going well. We'll do this another one more time. So 2 months from now, we'll give you 60 days. And if you've made your payments for that 60 days, we'll stop this regular contact and I'll just let you continue to make your payments. Thank you for doing so well so far, and I look forward to having that continue. That's all for today.
Thank you,
Thank you
Your
very
Honor.
much.
Thank you.
Take care. Next matter is Katie Kirk and Jacob Moore, file 18-17137-DS. I do see that Mr. Moore is present. Ms. Spillane, can you update me on this matter, please?
This matter was adjourned from June 26th to monitor the defendant's payments. He has a support obligation of $140 and a current balance of $2,718.05. Last payment received was back in June in the amount of $107.33.
Mr. Moore, what seems to be the issue with making your payments every month?
Well, to be honest with you, Your Honor, I seen on my pay stubs I had a child support being taken from my pay stub on my paycheck, so I automatically assumed the payments were coming through. Because it didn't it just said child support or something like that underneath all my taxes, where it was telling all my tax money coming out, and I thought it was coming out, so I just assumed that was going towards this.
Ms. Spillane, do you have any information as to that?
I'm looking at his payment history right now, and we have not received anything. He may want to check in with his employer and make sure that money is actually being sent in. And he can also send us a copy of that pay stub just to verify that money is coming out.
Would I be
Let's
able
do
to
that.
take screenshots of my pay stubs and just send them as an email?
You could.
Okay.
All right, so let's do that. Check with your employer, Mr. Moore, find out. Sometimes they take it out and hold it for a period of time before they cut a check to the friend of the court. I don't think they're supposed to do that, but that's not uncommon for them to try that.
Okay.
Or there may be maybe they thought it was being done correctly and it just didn't do it administratively somehow. So I don't know what their system looks like. So you need to check and say, hey, the friend of the court's telling me they're not getting anything. Where's the money going? And then you also, once you send that information to Ms. Spillane, she can confirm whether or not it's the correct amount that's being taken out to make sure that we don't have any problems in the future. So we'll reschedule this for 30 days from now, give you a chance to contact your employer, send that information that you are going to screenshot to the friend of the court as well. And hopefully you can get it all taken care of. If Ms. Spillane is satisfied that you've got everything taken care of, I'll give her the discretion to not have to have a hearing next month, as long as there's an order in place and it appears to be working correctly. Ms. Spillane, is there anything else that you would need for today?
No, sir.
Mr. Moore, any questions that you have?
No, Your Honor.
All right, good luck to you, sir.
Thank you.
All right, this is the matter of Nigel Ingersoll and Cassandra Ingersoll, file 23-19438-DM. I do see Mr. Ingersoll with Mr. Trush is present, and Cassandra Ingersoll is with us as well. Ms. Kraus, is this yours?
It is, Your Honor.
Can you update me as to this one, please?
For the, in regards to the Cassandra one, this was a hearing for the defendant on her failure to appear and a show cause for her at the last hearing. And then additionally, I think it's just no, that's it. It's for her failure to appear at the last hearing.
All right, thank you. Ms. Ingersoll, there's an order to show cause against you that indicates that you failed to appear for a scheduled review hearing on July the 10th at 1:30. You understand that allegation?
Yes, sir.
The failure to appear when you've been ordered to appear by the court can be punishable by contempt of court, which could include at a maximum 93 days in jail and or a $7,500 fine. You have the right to have a hearing if you wish to disagree with that. At the hearing, you could represent yourself. You could retain your own attorney. You do not have the right to have a court-appointed attorney. At the hearing, you'd also have the right to see, hear, and question the witnesses. You'd have the right to present your own witnesses and get a subpoena from the court requiring those witnesses to appear and testify. You could testify or you could choose to remain silent. And if you chose to remain silent, that could not be used against you. The burden of proof would be on the friend of the court's office to prove that you failed to appear. And that would be by a preponderance of the evidence. And then you also have the right to appeal. How do you want to proceed today? Do you want to have an attorney or do you want to have a hearing? What would you like to do?
I mean, I guess I don't know. I don't understand. I didn't show up because I was physically sick to my stomach. Even right now I'm shaking. I have so much. I'm sorry.
Did you go to the doctor and get a note indicating that you were unable to appear because you were sick?
No, it's like an anxiety, like PTSD, like being involved with Nigel, seeing Nigel, hearing his voice. All of that puts me in severe anxiety. And I physically couldn't bring myself to log in because I know how he is and I know how he acts. And I couldn't do it. I couldn't. I'm shaking thinking about it right now. Like he gives me so much anxiety, so much PTSD, and the way he is, he lied to you, first of all, at the last, and I've sent in an appeal for that judgment that you made. I've sent in evidence with my appeal as to why I don't think that judgment should go through.
Right, and you'll be given an opportunity to do that appeal. I'm not here taking that away from you. You certainly have that ability to appeal if you wish. The only question was why you failed to appear, because the court ordered you to be here and you've been here in the past. I had no choice but to move forward with Mr. Ingersoll's requests and to issue a bench warrant for you, or an order to show cause for you, for your failure to appear.
I understand that. That's why I'm here.
Okay. All right. So the order that you were referring to set some parenting time for the summer and then alternating holidays moving forward, and then a review hearing in April of 27 to find out what we're going to do about next summer. So that's still in place until and unless there is a change based on your appeal. So you certainly have the right to make your appeal. And I'm not going to stop you from doing that. The only issue is, what do I do about today for your failure to appear last time. The fact that you showed up today is really what the court is trying to get you to do, which is to show up when you're supposed to show up so that the court has access to both sides of the information.
I usually do. I just couldn't. I couldn't even physically
I
speak.
understand. I understand that. So, and the fact that you appeared today shows me that I shouldn't have to worry about you showing up in the future. You may need to speak with a counselor or a therapist of some kind, or have somebody that can sit with you or help you maintain your anxiety at an acceptable level. I'll leave those things to you. But we are doing this in a courtroom, and most of the time we're doing this via Zoom, so you don't have to be in the same room as him. And so that should
I
be some
understand that,
comfort
but
to you.
he lies to you. He lies to you, and every time we've been together over court, he's lied to you. And every time I try to defend myself, we both get reprimanded. He's a narcissistic, pathological liar,
Ms.
and I
Ingersoll,
can't.
Ms. Ingersoll, today is not about him. Today is about you.
Okay, well,
Okay.
that is why I didn't show up, because I cannot function with him around, in view, in sight, his voice, anything. He's given me so much PTSD. He's lied so many times to you guys, and you have a plethora of paperwork against him. I shouldn't even be sitting here right now. He should have zero rights to any children. He's abusive, and you have proof of that. He's abusive to
Ms.
women.
Ingersoll,
He's abusive
Ms.
to all of
Ingersoll,
his children.
Ms. Ingersoll,
I'm not going to allow my child to be abused. I'm not going to. You are asking me
nobody's
to go
asking
against
you.
my motherly instinct and give my child up to somebody who is a proven abuser. I'm not going to do it. I
Ms.
can't.
Ingersoll,
I'm not going to
Ms.
go against my
Ingersoll,
motherly
we're not
instinct.
here about that today. Ms.
That is
Ingersoll,
what
we're
we're here
not.
about. That is exactly what we're here about. I didn't show up because he's a liar. I didn't show up because he is a narcissistic liar.
Ms. Ingersoll,
I couldn't sit in a courtroom and not have something to say.
it's clear to me that you know how to say things.
Not when he's sitting there, because he doesn't allow me, and neither do you.
You're doing it right now.
Yeah, because he's not here to bombard me and interrupt
He
me.
is here.
And
Ms. Ingersoll, he is here. He's in a panel on my
he's
screen, just like he is every other time. So,
okay. And any other time we can hear each other and he can talk
Ms.
and we
Ingersoll,
can see each other. Listen, I'm
Ingersoll.
telling you, the reason why I didn't show up is because I physically cannot be in his presence. I can't. It makes my chest hurt. It makes my stomach turn. It makes me want to throw up. I'm shaking.
Anything else that you want to tell me before I get a chance to say something?
No, say whatever you want.
Thank you. Please listen carefully. If you had not gone on that rant, what I was going to say was that because you showed up today, I'm not going to take any sanctions against you. It is very clear to me that you are able to speak your mind when you wish to. Mr. Ingersoll and his attorney are present today, just like they have been for every other court hearing. And I have never found you to be unable to speak in his presence in the past. So I will expect you to be at every court hearing in the future. If you wish to make an argument that you believe what he is saying is not true, you will be, like you have in the past, given an opportunity to do that. And I will make a decision in an individual case whether or not I believe him or I believe you. But simply ranting isn't going to get you or anybody else where you need to go. So for today's purposes, there will be no sanction against you because you showed up. In the future, if you fail to show up, I will sanction you then because you have been warned now. Have I made myself clear?
Crystal.
That's all. That's all for today. Thank you very much.
Your Honor, if I may.
Mr. Truce?
I know this isn't exactly what we're here for today, but I mean, I do want to at least address it so that it's clear to everyone. At the last hearing, the court did order 2 weeks of consecutive parenting time to take place in August. I've reached out to Mrs. Ingersoll, and communicated that to her that order is in place. She indicated to me that she intends to appeal that order, which obviously she's welcome to take whatever legal courses are validly available to her then. Frankly, I think she's past her timeline for it, but that's not here nor there right now. By my math, unless that exchange takes place by Monday, there's no way that she could possibly comply with that order, which still remains the valid order of the court at this time. Uh, I have indicated to Ms. Ingersoll, I am willing to assist in the, making the arrangements for that. But I think I do need to indicate that if the exchange doesn't take place by Monday, we're going to have no recourse other than to file a violation of parenting time with friend of the court, as well as potentially turning over to the state police for kidnapping, custodial interference, for not following the valid order of the court.
Can I say something now, please? Because Richard and I spoke on the phone, and I'm sure it's recorded, and I would love for you, Judge, to hear that recording. I did send an appeal to the friend of the court in writing, which is what I was told to do, and that appeal is dated for the 26th, which my end date was the 31st. So that's in time. I don't know where that appeal would be. I don't know what happened to the envelope, but I sent it out and it was dated for the 26th.
Did you
So
send a copy to Mr. Truce?
I didn't know that Mr. Truce was Nigel's lawyer until after the fact. He called me, he messaged me and said, "Hey, can we be in contact about this?" And I said, "No, sir, I sent in an appeal." I didn't know that Richard was his attorney until after I had sent in the appeal.
Well, now you know that he's the attorney. Would you please send a copy to Mr. Truce? And then
I don't have an exact copy. The friend of the court has the only written copy that I sent. I wrote it in handwriting like I was told to do. A written appeal. I
how
didn't
are
know that
you
I
going
had to do it twice.
How are you going to know what the appeal is if you don't have a copy of it?
Because, I mean, I know what I wrote down on the paper. It's not going to be the exact same wording. I can write everything back down again. I sent in proof of him lying to you in court. I sent him proof of him being abusive, admitting to giving his son bloody noses. I've sent the court a fair
All right,
amount of evidence to
slow
appeal your
down.
judgment.
I'm not the one that hears the appeal. You're appealing my order, so it's going to go to a different judge. Okay, so
Okay, well, I did send in that appeal in time, so I haven't
great.
kidnapped
Great.
my own child, the child I've been taking care of for 5 years by myself. How do I kidnap my own child?
Mr. Truce has told you what he intends to do. You've told Mr. Truce what you intend to do. I'm going to wait for everybody to do what they're supposed to do. If there is a violation of the court's order, we'll address that once it happens. That's all for today. Thank you very much.
Thank
Thank you,
you.
Your Honor.
This is Kimberly McQueen and James Galt, file 26-20384-DS. Mr. Galt is at the jail. We have Ms. McQueen with us.
We do, but she's not showing up video, so she may have to restart.
There she is. All right, Ms. McQueen is with us as well. Looks like there was a review hearing set for today to address custody, parenting time, and support after mediation. The court has received what looks like a copy of the mediation agreement dated August the 4th. Are there other issues that need to be resolved between the parties as the information been sent to the friend of the court so that they can make a child support determination?
The only thing is that has changed is I do not receive SSI anymore for the twins, for the child support. That was the only thing I needed to add in there. I just received paperwork stating that there is gonna be no longer payments as of 8/31/2026. So I believe James should start helping out when it comes to income, because it's starting to get pretty expensive with 2 4-year-old boys. They're about to be 5 and they are starting school this year.
All right, so have you given that information that you just quoted to the friend of the court's office yet?
I just received it yesterday, Your Honor.
All right, so that needs to be forwarded to the friend of the court. Do you believe that that makes a significant change in your income level?
Yes, Your Honor, because otherwise, I'm a single mom of 4. The only thing I was able to do was DoorDash and Instacart. So honestly, the SSI helped out with all the children for paying for their needs, and now it's down to whatever I can make. And I have the 4 children 99.9% of the time, so I believe that he needs to help out with something.
All right. Ms. Kraus, I believe my memory is that there is a threshold for change in income before the friend of the court can do a new review. Is that correct?
There is. I do believe that this is a brand new case, so I'm looking to see if there's been a order entered.
All right, I don't, thank you for reminding me of that. I don't think there has been one. So here's what I'm going to do. Ms. McQueen, if you would send a copy of that document that you got from Social Security Administration to the friend of the court, now that a mediation agreement has been reached as to custody and parenting time, the friend of the court should be able to do a child support recommendation based on the number of overnights that are agreed to between the parties. Mr. Galt, do you have any additional information that you wish to advise me of?
No, Your Honor. No.
All right. The friend of the court's going to need financial information from both of you. Mr. Galt, do you have access to somebody out of the jail system that can assist you with sending financial information, tax records, that sort of thing to the friend of the court?
Not all of that, no. But I only have a few weeks left, and I should be out.
All right.
But other than that, I don't have somebody that can get all my personal info like that. Everything's on my phone.
When are you going to be out of jail?
It should be a couple weeks. I'd say by the end of the month. I'm hoping before their first day of school.
All right, I'm going to require you to have your tax information for the last, Ms. Kraus, 2 years or 3 years? Which do you prefer?
Preferably if it's the same job, 2 years. It depends on the type of work that he does. If he's self-employed, we would probably have to have a conversation in regards to specific information.
All right, I'm going to say 2 years, and if once you get it, you need additional information, just simply request it, and he should comply with that. So, Mr. Galt, I'm going to give you until Wednesday, September the 9th. That's the second Wednesday in September. So you've got 2 weeks left in August, and then you've got so it would be three and a half weeks from now, basically, was when that information would be due at the friend of the court's office. So September the 9th, get that information into them by then they will do a recommendation. Both of you will have that sent to you, and if you agree with it, that will become the order of the court. If you object to it, there'll be a hearing on whether or not that is accurate information that was used, and then the court will decide whether or not that is to be the numbers used for child support going forward. Ms. Kraus, is there anything else that you would ask of the court at this time?
No, not at this time.
Ms. McQueen, do you have any questions?
I just want to clarify. So I need to send in a copy of both for the boys to their SSI, stating that it is no longer set for me to receive it. Otherwise, do I need to send in tax information as well, or is that just for Galt?
Yes, thank you for reminding me of that. Yes, you do need to send in the same information. So taxes for the last 2 years to the friend of the court, so they can determine what your income level is, the same as with Mr. Galt.
Okay. All right.
All right, Mr. Galt, do you have any questions?
No, sir. Thank you.
All right. Ms. Kraus, do you have a copy of the mediation agreement?
I do.
All right, and is that sufficient for your needs for parenting time purposes?
I have not completely reviewed it. If it outlines what their parenting time is in regards to overnights, yes. If not, if the parties could relay what their overnights are, that would be helpful.
I think it basically says, Mr. Galt's parenting time is Mondays at noon until Wednesday at 6 p.m. And then every other weekend, beginning in September. So until school, there's a certain overnights, and then it's every other weekend after that during school. And then it's the parenting time guidelines for the holiday schedule after that. So it does state it. There is no specific number listed for yearly overnights, but I think you can calculate it fairly quickly.
Thank you.
So, all right, that's all for today then. Thank you all very much.
Thank you.
The next matter is Nigel Ingersoll and Krista Carnahan, file 15-15991-DM. This is a support motion by Ms. Carnahan, and then we also have a review on a parenting time issue by Mr. Ingersoll, I believe. So Ms. Carnahan, your matter first. What is it that you would like me to review as to the child support matter?
Riot has a medical bill that I had submitted for his orthodontist. I would like you to take a look at it and see if it could possibly be calculated in along with his child support. It was ordered that Nigel was supposed to pay 76% of Riot's medical. However, he hasn't been helping with anything, so I kind of.
Yep. I think the number was 74% and 26%. 26 for you, 74 for him. But let me hear from him as to how he wishes to proceed. Mr. Trush, as to the support matter and the amount that's been listed for medical services.
I'm sorry, Your Honor.
How does your client wish to proceed? Ms. Carnahan, or excuse me, Ms. Carnahan has listed an amount of extraordinary medical with Dr. Sarya for, looks like $6,550, or actually $6,750 for orthodontics. Typically that would be divided out according to the percentage in the support order at 74 and 26%. Is there some reason why your client does not wish to do that?
Well, Your Honor, for today's purposes, I guess I would just indicate to the court, I mean, I haven't received any of that information or been able to go over it with him yet. That might be partially my fault. I think our original appearance was a limited appearance on the matter, but I haven't received the information to be able to go over it with him. So I would just ask the court to potentially set another hearing where I can go over that with him, discuss whether or not that's appropriate or not, or whether we agree with it or not.
How'd you get notice of today's hearing?
From the court calendar. So to be clear, Your Honor, when I came to the original hearing and took the case on, I went to the court's calendar and docketed all the existing court dates. This court date and time was existing at that time. I think that what was existing was probably the review hearing for the parenting time, not this particular hearing, but they're set at the same time.
Ms. Carnahan, did you send a copy of your motion on support to Mr. Ingersoll?
Yes.
There's a certificate of mailing at the bottom of this motion. Is that your signature at the bottom?
I'm sorry.
You have that?
Yes.
Yeah,
Yes.
I'm looking at the motion regarding support, and it says there's a heading underneath where it says notice of hearing. It says certificate of mailing, and there's a date of 7/9/26 and a scribbled signature. I'm assuming that's your signature.
Yes.
It also says hand delivered. So how did you make the service on Mr. Ingersoll?
In his mailbox.
Did you use the post office or did you place it in his mailbox?
No, I just dropped it off.
Did you put a stamp on it and put it in your mailbox so that the post office delivered it to his mailbox, or did you physically go to his mailbox?
I will resend it out through the mail. No, I just went and dropped it off.
So you never gave it to him personally? Is that correct?
No.
All right. He's entitled to notice of this, and if you can't prove that he got the notice, I can't require him to respond to it today. If you had actually delivered it to him, or if you had mailed it to him, then I could require him to respond to it today. But because I can't show that, I will have to have another hearing date set on your request for that. So we will
All
do
right,
this
I will.
again. Okay, so I need you to
I'm sorry.
send a copy of it and then fill out what's called either the certificate of mailing or a note, proof of service, which says I mailed it with a stamp on it at such and such a date, such and such a time. Or if you hand deliver it to him or however you get it to him, I simply need to have proof of that with, so you'd give it to him, and then you'd send a copy of that proof of service that this is how I got it to him, Judge, to the court so they can file it. So I have that for the next hearing, okay?
Okay.
And Your Honor, with Miss Carnahan's permission, I mean, I can reach out to her after the hearing and give her ways to deliver it to me. I mean, I'm happy to accept service on Mr. Ingersoll's behalf for it.
Thank you very much, Mr. Truce. So Ms. Carnahan, he's trying to make it easy for you. So how do you want to get a hold of each other after the hearing? Mr. Truce, do you have a number for her, or Ms. Carnahan, do you have a number for Mr. Truce?
Yes, does he have an office in town?
He's
My
in
office is
Grayling.
in Grayling, but I mean, I can give you the office phone number.
Why don't you
Yeah,
do
I'd
that
rather,
so she can set it up?
I don't want to put my phone number on
Yeah,
over Zoom.
he'll give you his, which is a public number, so that way you can call him.
What's your number?
It's 989-745-6625.
All right.
Sir, is it possible to get an updated address
What's
for
that?
Mr. Ingersoll, since we have a bunch of return mail that keeps getting sent back?
Absolutely,
Yeah.
but I'm not putting my address online. I'll stop in and provide that for you personally, or I'll call after this is over. No
Please
problem.
do. Thank you.
Yes, ma'am.
All right, so we've got that issue at least preserved, and that we'll deal with that at the next court hearing. The next matter that we have then is a review on parenting time. And what is it that you want me to know about that, Mr. Truce?
Your Honor, essentially since the last hearing, there has not been any parenting time. When we were last here, there was, and I'm, excuse me if I misstated, but I think it was makeup parenting time that was supposed to happen during Alpenfest. That ultimately didn't happen, and I don't think there's really been any parenting time since then. There is an issue that I do think we need to address about how parenting time is supposed to occur, because this past Sunday, Mr. Ingersoll went to exercise his parenting time. The police were called with an alleged violation of a PPO. And ultimately, there's some question over how this exchange is supposed to take place, given that it sounds like the present state of things that there might be a personal protection order.
So specifically, Mr. Truce, what are you asking for?
Well, I guess at this point, I think this was set again for a review hearing of that prior to today's date already. I think fundamentally what we need to assess here is parenting time has not been happening. And from my position, I don't see a good explanation as to why it's not. What's consistently being told to me is that Riot does not want to engage in the parenting time. I've indicated it before and I'll continue to indicate it. I don't think that it is good policy wise to let a 13-year-old drive the bus, so to speak. I also, I would want to know what steps it is that Ms. Carnahan is taking to assure this, because to the extent that she's letting him just say I don't want to go and that's the end of it, I don't
Agree
think
on debts and
it's
assets. We do not agree on who claims the children.
Sorry about that. That was another party, not Ms. Carnahan. Go ahead, Mr. Truce.
So I mean, I think that's what we're here for today. I mean, obviously our request is going to be that makeup parenting time be ordered, and that parenting time actually occur as it's supposed to.
Ms. Carnahan, who is the counselor for Riot?
Pam from Old Town Psychological. She submitted her letter of recommendation.
Submitted it to who?
She mailed it out on Tuesday. I also received a copy of it.
Mr. Truce, did you get such a letter?
I have not. I've had no communications from the counselor to me. The court did request Mr. Ingersoll to reach out to the counselor. He did that, but was basically told unless he's a client or does an intake with them, they won't talk to him.
I have not received such a letter, Ms. Carnahan. Is Pam here and available for testimony today?
She submitted her request. Other than that, she does not feel comfortable after Nigel called and verbally abused her staff members. It was also wrote in the letter of recommendation.
Well, since I don't have that letter of recommendation, I don't know those things. The hearing was set for today, and it was made very clear that the counselor was to be subpoenaed to be here. And it was also, hang on, let me finish my thought. It was also noted that the parties were to use the counselor and that she was to make interim recommendations as to how things were going with Riot, so that, in Mr. Truce's words, Riot wasn't driving the bus. It was the counselor who was driving the bus. Why did that not occur?
It was submitted that she was supposed to submit in writing, not in person. And she said she does not feel comfortable with the way Nigel called and verbally abused her staff and the confidentiality with it being over Zoom and broadcasted. She wanted to keep Riot's counseling private for the things that have happened.
Then we'll set an in-court hearing. She can be here for that, but you need to subpoena her for that. Mr. Truce needs to have the ability to call her and talk with her about concerns with Riot and parenting time. And parenting time needs to take place. How do you propose that we do all of that?
Your Honor, after the last couple of attempted visits, Riot has refused to go, and he and Riot's counselor does not feel that it's safe. Nigel came over here. He shoved Riot off the porch, tried to drag him to the vehicle. And then last Sunday, he pushed his way into my home. Riot was quite distressed. I took a video of it. And then we have also had false police reports. The police were at my house the other day. Some of Nigel's friends have filed false police reports, and they have been talking to, the police showed up and had to talk to Riot. Riot is, it's just not working. At all my attempts to get Riot to call his father and have an interaction, the interaction is so negative that it has affected him horribly. It's affected his school. It's affected him emotionally. You cannot attempt to have a relationship with your child and put your hands on that child.
All right. What I'm going to do is I'm going to reset today for a future court hearing on the same issue. Ms. Carnahan, you're going to need to subpoena Pam at Old Town. We'll have this hearing in person. I'll set it for a 2-hour hearing. So Ms. Carnahan, you're going to need to contact Samantha Johnson, who's my scheduling person, to find a 2-hour hearing date for that. And then you're going to need to get a subpoena from the court, which you will fill out, and I will then sign, and that will be given to Pam to require her to attend at that next court hearing. The letter that you've indicated that the counselor has sent out needs to be sent to Mr. Trush as well. So if you have a copy of that, that needs to go to him so that they have access to that information for any questions that they may have for the counselor. And then we will schedule this hearing and have the hearing, and each side will be given a fair opportunity to bring out whatever facts they believe are necessary regarding ongoing parenting time. And I'll reserve making any decisions about how ongoing parenting time is going to look in the future for that hearing. Mr. Truce, do you have any questions about that?
Your Honor, just in the interim, what I mean, is the present order and is it continuing in effect? I mean, should parenting time be continuing to happen? Is the court ordering any makeup parenting time? Because again, there's been a significant amount of missed parenting time. And then lastly, to address how the parenting time exchange should occur, again, given that, and Ms. Carnahan didn't address this, but I don't think she disputed it either, that there's a PPO and we don't want to be dealing with a violation every time that parenting time is attempted.
All of which is a great reason for us to address that at a court hearing where I can adduce facts and have specific information in front of me before I do anything else. So the court order has not been changed. If there are ongoing violations of it, I will address it at the next court hearing. If there are ongoing valid reasons for not complying with it, then I'll see that at the next court hearing. But it's not productive for me to make a decision without facts, and I'm not going to be able to have all of the facts that I need without the counselor testifying. So it's not going to be productive for me to make a stab in the dark. So I'm going to do this all at one time when the counselor is here, the parties are here, and I can hear all of the evidence at the same time, and then I'll make a decision on all of those issues. So Mr. Ingersoll has not lost his ability to have makeup parenting time if I decide that that's appropriate. It's just not going to be immediate. It'll be after the court hearing, and I'll allow him to address any missed parenting time, including from now until the next court hearing, if that's what occurs. If Ms. Carnahan is able to give ongoing parenting time, then there may not be any loss of parenting time. I don't know that. But I'll have the hearing in the future when everybody's here. Ms. Carnahan, do you have any other questions?
No, Your Honor.
Judge, if she calls next week, I will not be here.
Your Honor, I'm sorry, just one additional
Go
issue
ahead,
I did
Mr.
want to address.
Go ahead.
And again, I don't want to beat a dead horse, but the issue of the PPO and how the exchange should take place in the interim, I would suggest if Ms. Carnahan is agreeable to it, the city PD has indicated to me that their front parking lot is under camera and they do custodial exchanges there for that reason. So I would suggest, at least until we can get another court hearing, that parenting time exchanges take place there so that there is camera footage of everything that happens in case there is, you know, any sort of allegation.
Thank you, Mr. Trush. All right, that'll be the order of the court. Ms. Carnahan, please contact the court to get the court date set and issue the subpoena. And we'll see everybody in court as soon as we can. Thank you. That's all.
Your Honor,
Yes, ma'am.
would we additionally address her support motion at that same hearing?
That's a great idea. Let's do that. We'll let you know when that's going to be set and schedule it together. Next matter is Stephanie Kuhn and Alexander Kuhn, file 25-20033-DM.
Good morning, Your Honor. Courtney Cadot, Legal Services of Northern Michigan, standing on behalf of Angel Kelly Anderson as attorney for plaintiff Stephanie Kuhn, who also appears to be present via Zoom.
All right, I do see Ms. Kuhn. Do we have Alexander Kuhn with us as well?
I'm present, Your Honor.
You turn on your video, sir?
I'm currently on just a phone call. I do not have video at this time.
All right. Please listen carefully then. It appears I have a proposed consent judgment of divorce. It's been signed by everybody and signed by the friend of the court. Mr. Kadat, do you wish to take the proofs at this time?
Yes, please. I wish to take questions from Stephanie Kuhn with at least 1 or 2 follow-up questions from Alexander Kuhn.
All right. Would both Mr. and Mrs. Kuhn raise your right hand so I can swear you in, please? Do you both solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Kuhn?
Yes, Your Honor.
Mr. Kuhn?
I do.
All right. Thank you very much. Mr. Kadat, go ahead.
Stephanie Kuhn, will you state your name for the record, please?
Stephanie Michaela Kuhn.
And did you file a complaint for divorce against Alexander Kuhn on or about March 26, 2025?
Yes, I did.
And at the time that you filed your complaint for divorce, were either of you residents of Michigan for at least 180 days and of Otsego County for at least 10 days?
Yes.
And were you married by a person authorized to perform marriages on January 21st, 2021 in Virginia?
Yes.
And has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Are you currently pregnant?
No.
And did you have minor children born or adopted during your marriage to Alexander Kuhn?
Yes.
And what are their names and ages?
Lavian Kuhn, he's 6. Lennox Kuhn, who is 1, and Elias Kuhn, who is 4.
And did you reach a custody determination with Alexander Kuhn, giving the two of you joint legal custody and you primary physical custody of those 3 minor children?
Yes.
And have you also reached a parenting time agreement with Mr. Kuhn as laid out in your judgment of divorce?
Yes.
Do you believe that the parenting time and the custody are both in your children's best interests?
Yes.
In your judgment of divorce, do you understand that there is no spousal support awarded and neither of you can come back in the future and seek spousal support from each other?
Yes.
And have you reviewed and understand the division of property, being that each of you retain what's in your possession?
Yes.
And do you believe that to be a fair and equitable division of the property that was accumulated during the marriage?
Yes.
And the copies that the court has, I believe, say that Ms. Kaylee Anderson signed the proposed judgment on your behalf. Is that an accurate representation? Is it your wish that the court grant the proposed consent judgment of divorce today?
Yes.
So that is it for.
Go ahead, sir.
That's it for Ms. Kuhn. I would like to verify with Mr. Kuhn also that the terms are as agreed.
Please go ahead.
So Alexander Kuhn, can you state your name for the record?
Yes, Alexander Kuhn, last name Koon.
And Mr. Kuhn, did you hear the testimony of Stephanie Kuhn?
I did. I heard it.
And were there any inaccuracies, errors, or omissions that you observed in Stephanie Kuhn's testimony?
No, other than I would like more parenting time, but that's not for us to go over today. We'll address that in the future.
And so did you also receive the proposed consent judgment of divorce with attached uniform child support order?
Correct.
And did you also give attorney Angel Kaylee Anderson permission to sign your name on your behalf to those documents?
I did.
No further questions for Mr. Kuhn, Your Honor.
Thank you, Mr. Kadat. Mrs. Kuhn, I note in the proposed judgment of divorce that you're asking for your former name to be restored. Is that correct?
That's correct.
And is the spelling of that last name Brozo?
Yes, Your Honor.
All right, just want to make sure we had that correct. Do both of you understand that you, by this divorce process, that you would be giving up any claims that you would have on the other party's pension or retirement accounts?
Yes, Your Honor.
Mr. Kuhn?
Yes, I understand that. Just to be clear, does that include VA benefits?
It does, my understanding. So you would keep yours and she would, if she does not have any of her own, she would not have access to that. Is that what you understand, sir?
I'm just trying to clarify, is that subject to garnishment for child support?
I can't make a decision about that because it hasn't occurred yet. So garnishment is a totally separate thing, but you are the right one who would have the VA benefits. Whether or not she can garnish it is something outside of the divorce for whether or not child support is available. So that's not for today's hearing. The issue is not garnishment. The issue is who has the retirement account. Right now, if you're the military member, you would have the VA benefit. Do you understand that?
Yes, I do. Thank you.
All right, Ms. Kuhn, do you understand that as well?
I do.
All right, are both of you asking me to sign this judgment of divorce?
Yes, Your Honor.
Yes.
All right, I do find that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. I also find that the custody and parenting time arrangements appear to be in the best interest of Lavion, Lias, and Lennox, given their young ages, and that the child support matter has been addressed by the friend of the court, has been signed off by the friend of the court, and does appear to be accurate and appropriate as well. So I will sign. I do find the property settlement to be appropriate and equitable as well, so I will sign the judgment of divorce and date it with today's date.
Thank you, Your Honor.
This documentation will now be sent to the clerk's office. Once it reaches the clerk's office, they'll file it, and the copies can be obtained from the clerk's office probably tomorrow at the earliest. Do either of you have any questions?
No, I do not.
All right, that's all for today then. Thank you both very much. Thank you, Mr. Kadat.
Thank you, Your Honor.
Thank you.
All right, next matter is Rodney Goddard and Tiana Fowler, file 22-18909-DS. Do we have both parties present for that?
Yes, sir.
And yes, sir, Courtney Kadat on behalf of defendant Tiana Fowler is also present via Zoom. I believe I saw Rodney Goddard present also.
Yes, I do see Mr. Goddard. I do see Ms. Fowler. Thank you. I apologize. I didn't hear what you said, Mr. Goddard. All right, thank you.
Mr. Rule appears to be here as well. It looks like he's just not on video.
All right. There appears to be a objection to the referee's recommendation filed by Mr. Goddard, and there's been a response filed by Mr. Kadat on behalf of Ms. Fowler. Mr. Goddard, why don't you tell me what your objection is and what you want to do based on that objection?
Your Honor, there is an NA case that is part of this, and that is being resolved. I have spoke with Ann Sullivan over the last couple of days, and she is dismissing the case against me. And we just need time to go to court and all that stuff. And I was going to ask if we could get a postponement to allow time for that to happen, as that could weigh heavy on the outcome of the case.
How is the NA case going to change what happened in front of the referee? Because that's what you're objecting to, is what happened in front of the referee. How would that, a new information on the case that happened after the referee's decision, how would that change anything?
No, this was part of it, Your Honor. The NA case was part of this, and that was part of that was the reason why my kids was removed, and that was part of what, Ms. Fowler's complaint was. And it'll open up new information that would, support me and help me.
Mr. Kadat? What say you with this?
So, Your Honor, from practical considerations, I think the most proper path forward is to deny Mr. Goddard's objection and instruct Mr. Goddard that he has the right upon the closure of that NA case to file a new motion based on the proper cause or change of circumstances that may in fact occur as a result of that case closure.
Mr. Goddard, did you understand what Mr. Kadat said?
Yes.
All right. I agree with Mr. Kadat. It sounds like you're saying there's going to be new information that should be used. But the posture of this case is at a moment frozen in time when the referee made his decision, you're objecting to that. And so
Yes.
new information wouldn't necessarily affect that unless you wanted everything reconsidered in light of the new information. So it sounds to me like that would be what Mr. Kadat suggested would be the appropriate way to proceed, which is to deny your request at this point and allow you to proceed in the future with a new motion based on what you think are changed circumstances, being that the NA case is going to be stopped or taken off against you in the future. Do you have any questions about that or any concerns about doing it that way?
No, Your Honor, I'm fine with doing it that way.
All right, so it would be on you then to simply, once that NA case has been taken care of, to file a new motion, and that would be on custody or parenting time or whatever you think would be appropriate, and say, here's why there's new information out there, and here's why I think it should change what the decision is. And then the referee can make another decision, and if you don't like that, you can object to that too. Does that make sense?
Okay. Yes.
All right, so I will then, for the reasons outlined in Mr. Kadat's response, deny the motion, deny the objection to the referee's recommended order, and that order will be the order of the court until such time, if ever, as Mr. Goddard is able to file a new motion and a new decision is made. Any questions about that, Mr. Goddard?
No, sir.
Mr. Kadat, any questions?
No question, Your Honor, but if I could direct Mr. Goddard to send a copy of whatever he files to me, so long as I am Ms. Fowler's attorney, that would be great.
All right, and that would be a very normal thing to do, Mr. Goddard. Once you file it with the court, you'd send it to the other side. Mr. Kadat is representing Ms. Fowler, so he would be the one to send it to in the future. All right, sir?
Okay, thank you, Your Honor.
All right, that's all for today then. Thank you both very much.
Thank you, Your Honor.
The next case is Lily King and Daniel King, file 26-20311-DM. Who we have present for that matter, please?
You should have both parties.
I am here, Your Honor.
All right, I do see Daniel King. I see Lily King. Both of you appear to be without attorneys. Is that correct?
Yeah.
All right.
Yes, Your Honor.
Thank you. This is a status conference. I think we had a status conference back in June, at which the parties were going to try to work out pending issues between themselves in good faith and with kindness. So where are we at in that process?
Might I to go first?
Go ahead, Mr. King. Yes.
Okay, we have agreed we have reached an agreement on assets and debts. I was keeping the federal and state 2025 tax return and assuming our marital debt. But we do not agree on who claims the children for the 2026 tax year. I believe that since the children were kept from me for no reason when we were supposed to share custody all along. As far as custody and parenting time, our current arrangement is not working. And since the temporary custody order has been entered, we had multiple communication issues, concerns regarding the children's welfare, while in the plaintiff's case, and both successful and unsuccessful attempts by the plaintiff to violate the order.
The order was entered, what, the beginning of this month?
Yeah.
I hate to tell you this, but it's way too early to start talking about having problems with a current order.
I agree, Your Honor. That's why I was wondering if, 1 second, if there's a way to go back to trial for all of this, to get it to re-talk about everything.
I don't think you understood what I just said. If you've reached a temporary agreement and it's only been, today is the 14th, and this order on temporary, well, that's the child support order. How long have you had the custody agreement in place? Since what, June?
Yeah.
So 2 months? You guys haven't even begun to figure stuff out yet.
May I
I
speak?
don't, in a minute, Ms. King, yes, in a minute. But in general, I'm not gonna have you guys redoing or recreating the wheel just because you haven't been able to talk to each other well in the first 2 months of a parenting time dispute.
It's
You're
just
in the process of having a dispute with each other. You got to learn how to do that. And the only way that you learn how to do it is by continuing to talk to each other. I'm not going to make this a final order because I want to make sure that the parties do have things settled down and taken care of appropriately. But I've got to tell you this, if you're giving up after 2 months, you're never going to have an agreement because you'll go back and recreate the wheel and 2 months later, you want to do it again. That's not how this process works. Okay, so you guys are going to have to learn how to talk to each other civilly. It doesn't mean you have to be best friends, but it does mean that you have to be able to talk to each other and you have to learn how to work things out. That means neither one of you is going to get your own way all the time. Sometimes it's going to be Mr. King, sometimes it's going to be Mrs. King, sometimes it's going to be neither one of you. Okay, all right. Any other issues from your side, Mr. King, and then I'll come to Ms. King.
So there was a few things about false statements made.
We're not going over that today. This is not an evidentiary hearing where one side says the other side did a bad thing. All I need to know is what issues are there that you guys need to work on.
We definitely still need to work on, I would like to get her into schooling and everything too. We haven't really been trying to discuss that with her.
How old is the child?
Heaven's 4.
She gonna be of school age this coming year?
She's gonna be 5. 1 second, let's get my paperwork.
Oh, when's her birthday?
March 4th,
Of next
2022,
year?
Your Honor. Yes, Your Honor.
So she's not gonna be eligible for school this year. They're not gonna take her for birthdays after December.
Okay, after December.
So she can get into preschool, which might be a good idea, and you guys do need to talk about that, but she's not going to be eligible for school this year unless her birthday was prior to December.
Yes, sir.
All right, any other issues that you have, sir?
Yeah, so I was wondering if like during the initial pickup, if so I have offered to have one of my trusted childcare providers pick up the children so that the time can be more consistent, but the plaintiff has refused. I personally do not have an issue exchanging the children with one of my plaintiff's childcare providers if she's unavailable at any time. I did bring up mediation at first so we could discuss it, but the plaintiff multiple times, she didn't want to participate.
So transportation and childcare is an issue?
Transportation for me, Your Honor, has not been an issue, no.
Well, who does the transportation? Transportation sounds like it's an issue.
I have been doing the transportation, so like I said, every Saturday night I will pick them up at like as soon as I get out of work at the end of the day, and then I will bring them back at Wednesday right before work or Tuesdays at that 8:30 at that Shell gas station in Marathon. Or the Shell gas station in Nebraska.
What was the information about your quote trusted childcare provider?
Can you repeat that one more time? I'm sorry, there's a delay.
You made a statement about a trusted childcare provider, and it sounded
She
like you
has-
wanted that person to do the transportation.
She has requested at times that like she wants a consistent pickup time, and I ride share with one of my childcare providers. We both go to work together, so I didn't know if it was ever an option for them to pick up the child at a specific time if they were off before I was.
So that's transportation. Right?
If not, I'm
Picking
all
up the child.
yes for her, but you guys said it was at the end of the day, and it's okay for that, and it's been working every day at 9-10 o'clock. But sometimes it seems like it's too late for her. Like I can't choose my day to be like I rescue a lot of people. I work for Amazon. I do my package delivering, and I get off at the end of the day as quick as possible to go and then pick up the babies.
All right. All right. Any other issues that you have, sir?
There has issues like I believe that she's denied preventive medical and dental care up until the point that she filed for divorce. And I just think the risk that, or misuse of medication twice now should not be under the impression that she gets to make major life decisions for her children, regardless of my opinions.
Do you guys know what custody means?
Yes, Your Honor.
Legal custody means that both of you get to make important decisions for the children. Physical means the day-to-day decision making, when they get up, when they eat, what clothes they wear, who they go see, that sort of thing. So if it's an important decision, both of you, unless there's some sole custody issue going on here, but I don't think there is at the moment, both of you are going to still remain involved in the major decisions, school, medical, religious, those sorts of issues, discipline, typically are joint decisions because you would have joint custody. Any questions that you have about that, sir?
And then what about lying to the doctor about a shared custody agreement, signing a non-vaccination form without my consent, even though I would like the children to be vaccinated?
Okay, Mr. King, here's what I hear you saying. You want to bring up a lot of stuff about that she's doing wrong, and you don't even have an agreement yet on everything. Okay,
No, we
so
don't. That's why I didn't know if it was easier to go back to trial to help get this situated, because
we
there's
haven't
not
been
been
to
agreement.
trial. You haven't been to trial yet. We're very in the beginning stages of this case. That's why I'm only asking for what the issues are, because you guys are going to have to talk about all of these things. And it's probably going to be a whole lot easier to talk to Ms. King if you're not alleging that she's doing something wrong every other minute. I don't have a problem with you saying, hey, I don't like what she's doing. Today's not the day for that. And if you're in negotiations, trying to figure out how to phrase it in a little less confrontational manner might be the best way to get your own way. Okay. So what I hear you saying is you've got some issues with medical. Those things need to be discussed.
Yep,
so I'm going to
medical and
send you to a place
communication.
in a minute. I'm going to send you to a place to do those discussions. But I just need to know what the areas that we need to talk about are. So, all right, now I'm going to turn to Ms. King and I'm going to ask her the same things. What are the issues that need to be talked about? Ms. King?
I'm here, Your Honor. I have no issues whatsoever. Any pickup times work for me, whatever times. I do not care. I don't care how late it is. All of them work for me. And then Heaven's curriculum, I've been trying to send it to him, but he told me no, so I didn't, but I will send it to him. We were doing the whole thing, and I'll send him anything that he needs. Also with the appointments and stuff, when he asks about it, I will send him any of the dates, whatever he needs, whatever I can do to make it easier for him and the children. Anything else, like if we can just talk about it, we can get through it. Whatever I got to do to make
All
this
right.
work.
Have you guys, other than trying to talk to each other, have you been to mediation yet? I didn't see
No.
any forms.
I
right.
did try bringing it up, but it was denied by the plaintiff.
All right. Well, it sounds to me like
I would
There
like
needs to be
mediation
some-
if it was brought up, but
All right, thank you, Mr. King.
Sorry.
Ms. King, do you have any problem with mediation? That is talking about resolving all of these difficulties in front of somebody who's trained in how to get people to talk well with each other and respectfully to each other?
No, Your Honor.
All right, so what I'm going to do then is make a referral to community mediation. They will give a phone call to each one of you to set up a date upon which you can go to the mediation office and discuss whatever issues that you want to discuss at that point, trying to reach a global settlement on all issues. They'll help you in recording, writing down, and making sure that the language is appropriate for that agreement. And if you are able to reach an agreement, typically what happens is that agreement is then sent to the court. The court has a hearing, make sure that it is still appropriate, and then that can become a court order moving forward with your case. And in that way, it often resolves a lot of the issues that are necessary prior to a court judgment of divorce. Do you guys have any questions about any of that?
No, Your Honor. Am I going to be getting that by mail? Sorry, that was a question. By mail,
Yeah.
I'd be receiving that. Okay, thank you.
And is the address that we have for you on Aranac Street in Standish, is that the appropriate one to send it to?
Yes, that is correct.
All right,
I do have one question.
go ahead.
I was wondering if possible, if it was okay to get the kids into counseling. I believe counseling is necessary for our children to help them cope with being involved in a shared custody situation. There is one.
Does that sound to you like something that you should discuss with the mother of your children?
Yes, Your Honor, I can do that during mediation. I'm sorry.
That's exactly how that's exactly how this works. Instead of asking
Okay.
the court to decide issues for you first, the first option is always talk to the other parent. Because if
When
it has
it's-
anything important for the kids, you always talk to the other parent about it.
If I'm not getting an answer, that's just okay. Can I come to you with the questions if I don't feel like we're coming to an agreement, though? Is that what mediation would be involved in? And then they would bring it to you?
The
Like
answer
if-
isn't yes or the answer to that is not yes or no. So I
Okay.
am not
No
an
problem. I
on-call
understand.
mediator for anybody.
Nope, I
You're
understand,
going to
Your
go to
Honor.
mediation. Your job is to try to reach an agreement there. If you can't, that's fine. But your job is to try to reach an agreement. After that, and you need to, both of you need to understand this. There are always going to be questions involving kids. You're never going to get everything agreed upon ahead of time.
Yes, Your Honor.
It's just the way it is. Okay. Kids are always going to have something new is going to happen. They're going to fall down and hurt themselves, and you got to go to the ER. One of them is going to have an issue at school that they need counseling for. Something's going to happen with work, and one of you is going to have to change jobs or change hours or whatever. So you're always going to have to be able to talk to each other and work together on how to resolve these issues. Some of the time, you're not going to get it done the way you want to get it done. And that doesn't mean that you just automatically run to court and bring up every little thing because you didn't get your way. Some people try to do that, and quite frankly, it backfires on them, and the judge understands that they're just crying wolf, and he doesn't do what they want to do because it's best if the parents resolve it. Even if they're not happy with it, it's always best if the parents resolve it. So
I
to
agree,
answer
Your
your
Honor.
question, we're going to mediation. If you can't solve it at mediation, I'm going to continue to make you try to resolve it yourself. And only, let me repeat that word, only if you've exhausted yourselves trying to resolve it, will I then step in and make a decision for you. But that's a ways down the road yet. So, Ms. King, any other questions or issues that you have?
No, sir.
All right. Do we have a telephone number for both of you on record with the court office?
Yes, Your Honor.
Mr. King, do we have your phone number?
Yes, Your Honor. I made sure that it
All
was
right.
given to them.
Good. So I'm going to make a referral to mediation. We'll give the mediation department each of your phone numbers. They'll call you. They'll set up a date for you to come in. Please try to make everything as much as possible about resolving the case and not just airing grievances. If you try to resolve the case, you got a much better chance of actually doing that.
I
So
do
we will-
believe that I did not have enough time, Your Honor, to figure out. I wasn't trying to air any grievances. There was a lot of paperwork to it that resulted to the things that I was trying to say, but I'm completely okay with talking to that about mediation and discussing it with them as well, so we can come to an agreement.
Good.
Thank
So
you, Your
we'll
Honor.
have mediation. We'll have you back for an additional status conference to see how mediation went in about 45 days. So we'll try to get you in on mediation within 30 days. And then you'll have a couple of weeks to practice, see how things go. And then you can tell me how things are looking at the next status conference. So you should look for a notice from the court in about 45 days for the next status conference date. Any questions that either one of you have at this point?
No, Your Honor.
I
All right.
did have one question, but if it's too late, I don't know.
Go
The
ahead, Mr. King.
plaintiff claimed to me that she's expecting her work hours to increase to 80 hours per week. And I just don't see how she'd be able to properly homeschool her daughter with that kind of work schedule. But I was just curious how all that was going to work. But if that's part of mediation, I can discuss that again with
Mr.
her.
King, are you asking, Mr. King, slow down. Are you asking me that question?
Am I allowed to ask her questions right now?
No,
Okay, then no, I'm not. I guess I'm not asking that question, Your Honor.
that's an issue that you can resolve in mediation.
Okay.
Some of those questions that you're gonna have, there may not be an answer to. You don't get to have all of your questions answered just because you want to ask them. Okay? If it involves your kids,
It does involve
then
my kids and their schooling. So that's why I was curious. Didn't mean to interrupt, Your Honor. I'm sorry. There's a delay in the mic.
sometimes you got to just take a breath, Mr. King. All right,
Yep,
that's all for today.
mediation. Yep, thank you.
That's all for today. Thank you. Alicia Westcott, Richard Lake, file 26-20356-DS. Mr. Rolla.
Good morning, Judge. For the record, Mike Roll on behalf of the state and the Otsego County Prosecutor's Office.
All right, I do see Ms. Westcott is with us.
There.
Mr. Lake is with us as well. This is a
hearing on behalf of Alicia Westcott.
All right, thank you very much. I appreciate that. I apologize for not realizing that you were there earlier. Are you on behalf of, let's see, for the defendant, Mr. Lake, did you have Mr. Funk at some point, or he withdrew, is that correct?
He's muted, Judge.
Yeah, Mr. Lake, I can't hear you at the moment. Still can't hear you, Mr. Lake.
There. Yes, I had Mr. Funk. He
But you don't
no, he got sick and I think he's still in the hospital.
All right, so you're representing yourself, is that correct?
Yes.
All right. Thank you very much. Have you seen a copy of this proposed consent judgment of support?
Yes.
And you've signed off on that, is that correct?
I have not.
You have some objection to it?
We were trying to submit all my financials when Dave ended up going to the hospital, so I didn't get to submit anything.
So what is your objection?
I have none. I'll sign it today.
So you have reviewed it though, is that correct?
Yes. Yes.
All right. Do you believe that the child support portion of it has inaccurate numbers?
No, no.
All right. Mr. Rolla, is there anything else that you want me to do other than sign this? Is there any other information that needs to be put on the record or anything like that?
No, Your Honor, thank you.
All right, Ms. Neros, from your perspective, anything that needs to be done today?
I guess not. The last time I spoke with my client, my understanding was that the parties had reconciled, and I thought they wanted to dismiss the case. When I submitted a proposed stip to dismiss the matter, the response from Mr. Rolla was that there's arrearages that can't be waived, but I'm not sure how that could occur when a support order has not yet been entered. So if the parties no longer are reconciled and cohabitating, I guess that's different, but that was my latest understanding of what's happened.
We are.
Judge, the arrearages go back to the filing of the petition. The mere fact that the parties have reconciled does not resolve that issue, which is why it can't just be dismissed. And that's not going to happen because there's money due and owing to the state.
All right, the parties, if they're cohabitating and the children are with the payer of support, can ask for an abatement from the friend of the court's office as to any current and ongoing support. Typically, however, Mr. Rolla is correct. If there's money due and owing to the state, then a judgment needs to be entered so that those amounts can be enforced. Those amounts need to be paid. And then as long as the parties continue to cohabit, they can stop ongoing current support, which in effect is what you're asking the court to do in your cohabitation process. So I think both of you are going to get what you're asking for, which is stopping ongoing child support. But Mr. Rolla is correct in protecting the rights of the state to claim the dollars that are owed to it for its past support payments, if any. So, Ms. Neros, any other objections that you may have?
No, thank you.
All right. Hearing that there are no objections as to the accuracy from Mr. Lake, and seeing that Ms. Westcott has already signed the document and understanding that she now wishes to have an abatement, I will ask, see, do we have the friend of the court on still with us?
We do. They're both here.
I'm here.
Which, Ms. Spillane, would this be your matter?
Yes, sir.
Would you make a note in the file to have some contact with Ms. Westcott and Mr. Lake to confirm that they are continuing to live together and then the work on the abatement process for me, please?
Yes, sir.
Thank you very much. With
Judge,
all
in
that
that
said,
regard-
I'm sorry, go ahead.
In that regard, it's got to be reported to DHHS that that's the case too as well, because apparently currently in the system, that is not reflective. So I wanted to make sure the front of the court knew that. So they'll have some, they'll know they have to contact them.
Thank you very much, Mr. Rolla. All right, I have signed the consent judgment of support, both on the child support side of things, on the UCSO and on the judgment. Documentation will go to the clerk's office. If anybody wants copies of that, they can get that from the clerk's office. And then the friend of the court, Ms. Westcott, Mr. Lake, if you follow up with Ms. Stinson from the, Ms. Spillane from the friend of the court's office, and then maybe DHHS as well, as to the abatement of your ongoing child support. That would be the appropriate thing to do.
Your Honor.
Your Honor, before you let them go, I think there's some confusion. Mr. Brzezinski just emailed, and he does not agree with what Mr. Rolla has said. So I think maybe it's best that we get him on the screen as well.
Mr. Brzezinski?
He's in my office. One moment.
Hi, Judge.
You have some information for the court?
Yeah, I was talking with Ms. Spillane. It's our understanding that since the order hasn't been entered, there is no accounting in our system, and the money is not retroactively assigned to the state for public assistance. So if we enter this order after this hearing, then only it would only be assigned to the state moving forward. So if the order is not entered, or if the parties have an agreement to not enter it, then it's not necessarily required for the court to enter it.
That's not correct.
If the
Judge, it's
court, excuse me, if the state has already incurred expenses, are you saying that the state is not going to be able to go after those expenses?
Correct, Judge. Since the support order isn't entered in the system, the money has not been assigned to the state. And so if the support order is entered today, money would only be assigned to the state moving forward.
That's incorrect.
What about birth expenses?
Those were all waived a couple of years ago.
Mr. Roloff?
Judge, by statute, it's retroactive to the date of the filing of the petition. Now, whether or not they choose to waive them future, and again, that could also include arrearages as to any child support that would have been due and owing during that time period. While it's true that the plaintiff can waive those and have things in the future not going, it doesn't erase those, which is why the petition is enforceable as to support and as to any monies due to the state back to the February 19th, I believe, 2026 date the petition was filed.
All right, here's how I'm going to resolve it. I'm going to leave. I've already signed it. I'm going to send it into the clerk's office as a judgment. I don't think that Mr. Lake or Mr. Westcott, Ms. Westcott would be prejudiced in any way because they can have it abated by going through the process that I've outlined already. So there's no prejudice to them. Mr. Brzezinski, I've signed the order. If you believe that the order is in error, you may certainly bring information to my attention and I'll deal with it in the future. But I really think if the state doesn't have any claim going forward, then there's no harm, no foul at this point. And just to be safe, I'm going to sign the order and send it in. So that's the ruling of the court for today. Thank you all very much.
Thank you.
All right, the last matter before the court on the docket today is Jamie Salzano and Joshua Salzano, file 26-20308-DM. All right, looks like Ms. Salzano filed a motion to remove the previous mediation agreement dated 6/24/26 and replace it with an updated terms agreement dated 7/13/26, as stated in the attachment A and B. So it sounds like you guys have updated your mediation agreement. Is that correct?
Yes, Your Honor.
You agree, Mr. Salzano?
Yes, yes, sir. Yes, Your Honor.
All right. Is there a, let me see if I've got the updated. What it looks like I have is a mediation agreement attached to the motion, which has some things written into it and other things crossed out on it. Is that what you intended to be your new agreement? And then there's a paper afterwards that says Mr. Salzano signed indicating an agreement to pay a certain amount of money. Is that the documentation that you want to be the new agreement?
I do believe so, unless you want to change it, Josh, to reflect what we talked about this morning.
Yes, I would like it to state that the owing amount total is 50,000 instead of 55,000.
All right, so here's what I'm sorry, was there some other parts that you wanted to add there, sir?
No, sir, I think I was rambling part, sorry.
I do that on a regular basis myself, so I understand. So here's what I think would be best. It's always difficult in the future, 5 years from now, 10 years from now, if somebody doesn't do what they're supposed to do, it's always difficult to tell what the exact agreement was if things have been crossed out and written in and there's different parts in different places. So what I'm going to ask both of you to do is to retype the entire agreement, and then both of you sign it and both of you date it so that we know exactly what it was and when it was, so that there's no future issue with that. Does that sound okay to both of you?
Yes, Your
Yes, Your
Honor.
Honor.
It stemmed basically from me having to have multiple funding sources for the buyout.
Yep, and
And the-
that's perfectly fine. I'm okay with what you're doing and why you're doing it. I just want to make sure that we've got it down in a recorded fashion that we can use in the future without having to piece things together or say, no, that wasn't part of the agreement. That was taken from here at a different time. And I just don't want there to be any problems with that. So who's the better typist?
That would not be me, sir.
I can have it typed up. Do we have to have another motion to submit the new typed
No.
agreement?
No, if you just want to get it typed up and get his signature on it and you sign it and submit it to me, I'll make notes in the file that says you're going to do that. Can you do that within the next 7 days?
I can do it within the next 24 hours.
All right, that would be great. We're not open again until Monday. So if you've got it here by Monday or Tuesday, that's quick enough for me to remember what we're talking about. I'll make some notes in the file to keep the file here until you get that submitted. And then once that's submitted, that will become the court's order for that. And I'll do a face sheet that says, based on the agreement of the parties placed on the record today, that will become the order of the court. Does that sound good to both of you?
Yes, Your Honor.
All right. So, Ms. Salzano, if you would get that typed up, get both of your signatures on it, both of the dates on it, and get it to the court within the next week. I will then sign that and get that court order on it. And I'll send a copy to each of you once the court order is attached to it as well, so that both of you have a copy of that. And then the original will reside within the court file. All right. Thank you both very much. Appreciate your time and your effort.
I'm
Look
sorry,
forward
sir.
to-
I do have one other question.
Yep. Go ahead.
Referee Legal did say that if we came up with our custody agreement, we could also include that in our motion today. Would
Correct.
that be something I could type along with our mediation agreement that we both sign and submit that as an order?
You
I mean,
can,
I'm not.
if I, yep. Is
I-
there do you know what it is right now in general, what that custody and parenting time agreement would be?
Yes.
Can you tell me what that would be?
I believe we're just doing 2 weeks on and off, like 3 days on, 3 days off. We rotate Sunday, and then 2 weeks after that, we'll switch those days of our 3 days on, 3 days off.
Is that your agreement, sir?
Yes, Your Honor.
All right. And what age and how many of the children do you have?
We have one child, he's 15.
All right. Is that custody and parenting time arrangement going to impact his schooling at all?
No,
It
Your
was
Honor.
designed. I'm sorry. Pardon me. It was designed around his schooling. He has a live lesson schedule part of the week and a in-home work schedule the rest of the week. So it was designed about keeping him stable during that live lesson period during the week.
Good. I'm
But
glad to hear that, because that's the biggest thing for children, is making sure that they've got that stability, and that the schooling as a part of that takes place on a regular basis. Have you made arrangements for any different time for the summer, or do you think that that's a year-round schedule would be best?
I would
I
just,
believe
Let me
a
ask
year-round
Ms.
schedule.
Salzano first, and then I'll come to Mr. Salzano. So do we have a summer parenting time schedule, Ms. Salzano?
No, we don't. I would just assume it would just kind of remain the same, but I'm open to whatever suggestions Josh has.
All right, here's what I'm going to want you to do then. I'm going to want you to talk to each other about that. I would also like you to talk about holidays, just because those tend to be issues at some point in the future as well. And you may need to talk about transportation, who's going to come and who's going to pick up and who's going to drop off, and where you're going to do it. And then if you can't agree, how is it going to get worked out? So those are just some of the things that typically people who are working these deals out need to talk about. So if you can type that up as well, reach that agreement, and get it to me under the same circumstances with typed and signed by both of you, I can sign that as part of the order as well. Anything else between the two of you?
No, Your Honor.
All right, that sounds good. Thank you both for being here today. I'll look forward to getting that documentation from